These electoral bonds are meant for a political party to be in power in perpetuity, because the amount of money through these means, which quote unquote are legitimate, will empower that party through capital to influence everything. This is the most unconstitutional, undemocratic, unfair scheme that destroys the very basic structure of our constitution. Free and fair elections is the basic structure of our constitution. This scheme is neither free nor is it fair. It's not free because the industrialists cannot say no. It is not fair because in that process, the political party in power gets the maximum capital, and the capital it wants, not for elections, for other purposes. That's very dangerous. Incentivizing, and I'm coming to the other main argument. Incentivizing, I won't take more than a few minutes on it. I don't want to trouble your lordships. Incentivizing the use of banking channels. Of course, you will get this legitimate money through banking channels. In fact, that's the perfectly rational way of enriching yourself. Perfectly rational way. But that's not a justification for empowering yourself. I can understand if there was a correlation between this and the election process, in which you must disclose how much you have spent, where you have spent. But that cannot be, because it is the candidate who is fighting the election, not the political party. As far as persecuting the person who has been given the money by that party to an opposite party, they will be persecuted. Well, why will they be persecuted? Well, let me tell your lordships, just to tell your lordships what the reality is. A big industrialist who has enormous power will give it to all political parties. And the party of the center will never hold it against that industrialist. Because everybody is benefited. The system enjoys this money. Enormous capital to the party that is in the center, and small little donations to the others. And everybody knows about it. It's not a secret. So there'll be no retributions. That why did you give it to that party? Because you've also got the maximum. Why should there be a retribution? So this whole argument that no, there'll be a retribution, why have you given to that party? Supposing I got 100 crores. I get 100 crores, but the donation shows that he has given 500 crores. I know that 100 crores come to me, 400 crores have gone somewhere else. And if for the 100 crores, the quid pro quo is 4, 5, 6 instances, then out of 400 crores, why should the retribution be more than just 4, 5, 6 instances? The same logic will apply. Same logic will apply. So why are you protecting those mullahs? And the most serious part, mullahs, which I said earlier, that I will never be able to go to a court of law. What you're doing is giving a protection to corrupt transactions by not putting that information in the public domain, because I will never know. So, mullahs, how do I move forward? Where do I go? I can't file an FIR because I don't know. I'll be subject to defamation. I can't go to court. I have under 156(3), I'll have to go to, I'll have to give some data. I don't have the data. So what court order are we talking about? Don't shield the process of corruption itself by allowing this to go on. If you want to deal with corruption, the first thing to do is to quash this scheme. This is the surest way for political perpetuity. Having said that, just 5 more minutes. Then, mullahs, the respondents argue that EBS is a matter of financial economic policy. It certainly is not. It deals with elections, nothing to do with financial policy. In fact, the EBS and amendments on which it is based changes the very ground rules of the electoral process. The very ground rules, which negates any presumption of constitutionality and on the contrary requires heightened judicial scrutiny. That's the answer to that question of financial and economic policy. Economic policy is the bearer bonds issue because that way you can bring black money into the economic system and pay tax on it. This has nothing to do with it. 2, he says, they argue that making the identity of donors an extension of secret ballot, the right to vote and donating of funds are distinct. The right to vote is secret ballot. Donation of funds cannot ever be secret. Three, he says there is no uneven playing field. I will demonstrate it to yourself that the entire field is uneven. Four, they say the respondent has distinguished ADR and PUCL on the ground that the information sought for in those cases already existed and just needed to be disclosed. In this case, Manoj, the only reason the information about the identity of donors is unknown in the present case is the structural design of the system. You have structured the scheme in such a way that it's unknown. So, Manoj, I really don't want to say anything more. All I can say is, Manoj, and Manoj, what is the public interest that is being served here? I don't understand what the public interest is. Public interest not to know, not to disclose. And who are you protecting? For what purpose are you protecting these people? You are actually protecting yourself because you know who has donated. It is self-protection, self-preservation, self-perpetuating. How can the public interest in protecting the identity of donors outweigh the public interest in the public's right to know? To be free from corruption. So politics, Manoj, as I said, it's impossible for us to get rid of free money, black money, Manoj. No country in the world has got rid of it. Let's be clear on it. All your lordships can do is to tell the government, this is not the way forward. You want to deal with it in a way that is transparent, that gives us the confidence that it is not for you, it is for the larger public interest. Thank you very much.
Thank you, Mr. Siddharth.
And Manoj, also I would say, I filed rejoinder submissions already to his submissions, Manoj. A court master may just upload them. All that I have said to your lordships is dealt with that in about 12 pages. Manoj. I'll give you a copy, because I didn't want to, Manoj, take too much time to read them. There are others also. I'm deeply grateful.
The core of our challenge is to the
Yes, Mr. Siddharth.
to the statutory provisions which prevent public disclosure. Those are the statutory amendments. The scheme follows based on those amendments, namely amendment to section 29C of the Representations of People Act and section 182 of the Companies Act. Those were the public disclosure provisions. The scheme, once the public disclosure comes in the scheme, there is no real scheme to survive. Now, this is to answer my Lord Justice Khanna's question. What are we challenging? We are challenging those two statutory provisions because once that goes, the scheme itself collapses. The basis of the scheme is non-public disclosure. Because with that, I would submit, why do we need, in rejoinder, 2 points only? Why do we need public disclosure? Because number one, as the US Supreme Court said, in Buckley versus Valeo, a political party may represent anything to the electorate. It may self-ascribe any label to itself to the electorate. But one of the best ways of determining what the party is about is where or who it is going to be most responsive to is where it gets its funds from. If that aspect itself is removed from the public domain, so a party can say X, take the money from Y or other interests, and the public has no way of knowing. So public information is necessary for voter to form its view into voting. That is a substantive right to vote, is an informed right to vote. And therefore that information as to who has given you money to, so that the voter can match what you are saying. Are you taking money? Are you a green party? You're claiming to be a green party, but taking money from oil interest. There are n number of examples. So that is one interest which is necessary. Second, the question fell from the court yesterday to the government that how will you prevent quid pro quo? Quid pro quo has been used by both sides very broadly. Let me just try and bifurcate it. One would be policy influence or policy capture. Strictly not corruption. Second will be legislative influence or legislative capture. Strictly not corruption either. The final stage would be corruption or bribery. The only, in my respectful submission, the only constitutional safeguard against preventing quid pro quo is in fact public disclosure. And one constitutional court in South Africa, I just want to place 2 paras. In rejoinder, normally I wouldn't place paras of a judgment. Only 2 paras because exact same situation arose in South Africa. And the Constitutional Court of South Africa has said that the only way to ensure that these other things, nothing can be removed in a polity, is a complex space. Surely we can't expect a perfect world. But from areas or zones of influence to movement to zone of corruption, that can be prevented by public disclosure. Your lordships will just have page 6654. 6654, volume 4. Volume 5, I'm sorry, my apologies. The case is titled, quite aptly, My Vote Counts. versus Minister of Justice. And Mullah, straight away, para 40 at page 6653.
What page does this case begin? 6-6?
Now, 6653 is the relevant portion. Bookmark number 6060.
Yes.
This is volume 4 of?
Volume 5, my lords. Volume 5. The reality is that private funders do not thoughtlessly throw their resources around. They do so for a reason and quite strategically. Some pour in their resources because the policies of a particular party or independent candidate resonate with their world outlook or ideology. Others do so hoping to influence the policy direction of those they support to advance personal or sectional interests. Money is the tool they use to secure the special favors or selfishly manipulate those who are required to serve and treat all citizens equally. Unchecked or secret private funding from all, including other nations, could undermine the fulfillment of constitutional obligations by political parties or independent candidates so funded, and by extension, our nation's rightful place. Then thereafter, our freely elected representatives must thus be so free that they would be able to focus and deliver to their core constitutional mandate. They cannot help build a free society if they are themselves free, not free of hidden potential bondage or captivation. Now, para 42 is important. I'll read only from the third line. Only when there is a risk of being exposed for receiving funding from dubious characters or entities that could influence them negatively for the advancement of personal or sectoral interests would all political parties and independent candidates be constrained to